Boleh bercerai dengan dia. Saya tak boleh masuk. Kenapa awak boleh duduk dalam ni?
Don't disturb.
Don't disturb.
Nama Sarah dan saya ini pun Sarah. Sejak saya ni kira tidak lalu.
Kalau baik awak jumpa bawa panas sekali turun. Hotel ni tak pernah jadi gini tak? Saya customer tempat sini. Kalau saya awak jumpa bawa, saya nak pergi bisnes sekian buat saya takut.
I'm so tired from Baraya and visiting everyone. I just want to sleep. Thank God I have a nice hotel to go to. I should probably change before I sleep. Who are you? What are you doing in my hotel room?
What do you mean? Someone told me to meet them here. Who are you?
Who am I? This is my hotel room.
Huh?
What?
But someone told me to meet
I don't
them
know
here.
you. This is my hotel room. I'm calling the lobby.
What?
The hotel authorities are on their way up. You're gonna answer to them. What is that? What are you doing? Are you deleting
I'm
something?
not
Were
doing
you
anything.
recording me?
I'm not doing anything.
You were recording me in
Move
there.
away. You're invalidating my rights. Move away. I'm not
You
doing
were recording
anything.
something. I saw you
I am not
delete
doing
something.
anything. I was just playing with my phone. I'm not doing anything.
You're gonna answer to them.
So before we move on, I would like to introduce myself. My name is Muhammad Iqbal Muslim. I am the general manager of Hotel Fadhilah. So we brought the guy downstairs, and the police are coming on their way. So before we move on, I would like for you to share your side of the story, so we would understand the situation better.
Okay. Well, I was coming back,
Yeah.
and then I wanted to change my clothes, and then suddenly there's a man in a cupboard. So I was shocked, obviously, because I don't know how he got in there. He's not any of my guests. He was not with me in the room. I don't even know him, and he claimed that someone told him to meet in this hotel room, but I never gave him a key. I don't even know him, and I don't even know how he got in. That's trespassing. This is my hotel room. I have access. Only I have access. No one else does. And he also claimed that one of your staff let him in. So I don't know about that. You have to, check that with your staff, obviously. But I'm just really traumatized, and I don't know. The guy was just trespassing, and it's a really creepy experience. It's really weird. You should really look into this.
So I understand your situation, and all of the staffs here from the Hotel Fadhilah, we want to apologize, and we want to tell you how sorry we are for the situation that happened. And we will release an official statement so that the public won't speculate things.
Okay. Well, thank you. I can't stop thinking about it. Can't sleep. After being arrested, the suspect was found positive for methamphetamine. He also had 3 previous records related to drug offences and is currently remanded under Section 117 of the Penal Code Criminal Procedure to assist in the investigation. The case is now being investigated under Section 448 of the Penal Code, and if convicted can be sentenced to a maximum of 3 years imprisonment or a maximum fine of 5,000 ringgit or both. However, the purpose of this video today is to discuss on whether the parties in this case can file a civil suit against those responsible, specifically under the issue of trespass and occupier's liability. The parties are Sarah, the victim, Hotel Perdana, and also the suspect.
In discussing the topic on trespass to land, we can refer to the journal article written by Mary McGregor in 1993 about trespass to private land. Trespass is a civil wrong or tort. It means any direct enforceable injury to persons, chattels, or land. However, with reference to this article, today we are using it in the sense of inference with the right to possess land. In this article, it has laid down some factors on the questions of what sort of acts constitute trespass. The article has provided that the act of trespass must be voluntary, but it need not be intentional. Trespass also must require some form of physical entry onto or contact with the claimant or plaintiff's land. That entry could be the defendant going onto the plaintiff's land, or putting or throwing an object or third person onto the plaintiff's land, or discharging some substance onto the plaintiff's land. If we were to apply these elements into the problem situation at hand to see if this case involves the matter of trespass to land or not, we can say that the suspect has indeed committed a trespass because he had voluntarily entered the victim's room, which he had no authority of. His entry into the victim's hotel room was physical and was on a land that was not owned by him. The land he was on was a hotel that he was not a guest of, and that hotel room he was hiding in is part of the hotel grounds. Therefore, he had no permission to be on the hotel grounds unless he was invited by the hotel guests themselves, which in this case he wasn't. However, this further questions the issue of can the victim, Sarah, sue the suspect or trespasser for entering the hotel room without permission. In this article by Mary McGregor, it also discusses on trespass, which involves in the interference of possession whereby the plaintiff has to prove that he is in possession of the land at the time of the trespass. The article further elaborated that those in possession of the said land has to be an owner or other person with an interest in land that includes a right of exclusive possession, such as tenant under a lease. Under these situations, only then they can make a trespass claim. But someone with only a license, a non-exclusive interest in land, like a person who has the use of a hotel room for a night, cannot make a trespass claim because they are not a rightful owner of the hotel and does not have full possession of the whole land. They are only there as temporary guests residing in that hotel. Therefore, the general rule is that since hotel guests do not have full possession of the hotel, they cannot sue a trespasser per se, even if that trespasser is breaking into a room under their name. Because although they have the rightful possession of that said room for a specific period of time, they are still not the owner of the entire hotel building. However, they may look into other civil claims under the law of torts, which is occupier's liability, but instead of suing the trespasser, they may make an action against the hotel for allowing this incident to happen in the first place due to their negligence. As for the trespasser, he could still be liable and sued for his trespass, but not by Sarah. Instead, by someone who has full ownership of the hotel, which in this case is the hotel management themselves. That being said, from this hotel trespassing case that we have chosen, there are two issues that can be made. The first being whether Sarah could sue Hotel Perdana for their failure to ensure that their hotel premise is safe for the hotel guests under occupier's liability, and the second, whether Hotel Perdana can sue the trespasser for entering their restricted hotel premise without permission. In discussing these issues, we will be incorporating these two case laws that we have found to base our arguments and analysis on.
The technical issue is whether Sarah could sue the hotel for failing to ensure her safety and the occupier's liability. So the case that can be used is the case of Tokong Tabari and Government of Sarawak and others. The facts of this case is that the person on behalf of the deceased and the plaintiff had sued Public Bank due to damage suffered by them when an explosion occurred in the bank, which was resulted by the defendant's negligence in failing to take care of the premise in which the gas pipes had already corroded or rusted, which caused a gas leak. The Government of Sarawak, through the Public Works Department, had also breached their duty by not testing any leakage that were to happen before installing the gas meters. Therefore, the government, through the Public Works Department, could be said to have breached their duty due to the consequential damage being reasonably foreseeable. It was also found by the court that Public Bank staff did not make any reasonable steps after being aware of the unfamiliar and unpleasant smell in the premises. This omission made by the Public Bank staff could be seen as contributing factor that led to the incident. Therefore, the staff were negligent. On the issue of occupier's liability, It could be said that the deceased would be seen as an invitee, as there was a common interest by the deceased and the defendant, as he was the customer at the bank. So based on the case of Indermore and Dames 1866, we could see that this case is the landmark case in proving the requirements for an occupier to be liable under an invitee. The first requirement is that the danger must be an unusual one. The second requirement is the occupier knows or ought to know of the danger. The third requirement is the danger is not known to the entrant. And lastly, the occupier had failed to take reasonable care to prevent damage from occurring by notice, lighting, guarding, or any other sort of ways. Therefore, the defendants in this case were held liable, as they had duty owed to an invitee in preventing an unusual risk, and the bank is expected to be a safe place to be in.
Although the facts of the case and the situation at hand are different, we can still distinguish the general rules in the case and apply it. The decision made by the court in the case of Takong Tabari against Government of Sarawak and others, 1996, was based on the principles laid down in the English leading case of Indermar against Dames, 1973. But before we move on further to apply these principles one by one, it is important to firstly note that, similar to the case of Takong Tabari, where Public Bank was the occupier in that case and the deceased was a customer at the bank, which makes him an invitee. Now, in this situation, Hotel Perdana was the occupier and Sarah was an invitee, as she was a hotel guest staying at Hotel Perdana. Being a customer at the bank or a guest at a hotel can be regarded as business visitors, where the invitee enter a premise, be it public or private, for a materialistic reason and actually bring economic advantages to the occupier. Now, applying these principles that was used in the case of Takong Tabari, the first requirement is that the danger must be an unusual one. In Takong Tabari, it can be said that it is unusual for a bank to be emitting gas and subsequently cause explosion and fires from it. Applying this principle to the situation at hand, it is unusual for a hotel guest to find an unknown man in their hotel room that only they have access to by a designated room key card. This would further raise the element of danger, because who knows what that unknown man could do to her if she did not realize that he was hiding in the cupboard. Hypothetically speaking, what if she was alone and helpless? If something were to really happen to her, other than the man just hiding in the cupboard, the man could have assaulted her, robbed her, kidnapped her. He could have done anything bad. There are so many possibilities. In fact, the news reported that the suspect was allegedly deleting something on his phone when he was being confronted by the victim, which means that he could have been recording her the whole time he was in the closet. To make a bit of an analysis here, in most cases found in the textbooks and case laws, this element will only be fulfilled if there was a physical damage towards the invitee which constitutes danger. However, I believe that we should also include damages that involve emotional and mental sufferings. For example, it was noted that ever since the incident happened, Sarah was traumatized and had trouble sleeping at night. Nothing was reported on whether or not there was an actual physical damage towards the victim, but surely it was a traumatic and creepy experience for anyone sitting in her shoes, and it should be considered as an unusual danger. The second requirement is that the occupier knows or ought to know of the danger. To apply it to the situation, it was claimed by the suspect that one of the hotel staffs had allowed him into the victim's room. This is a very suspicious claim and should be investigated thoroughly, because assuming that the staff really did allow him into the room, this proves that the occupier ought to know of the danger. This is because the staff should have known that a random man asking to enter a room that he does not have a key to would raise some suspicion, and he should have reported it to his superiors in cases like this where it is suspicious. If the man claims to be a guest at the hotel and asked the staff to allow him into the room, why does he not have a key? Why does he need the help of a staff to enter into his own alleged room if he really was a guest? And why was the staff of a 5-star hotel so naive to let a random man into a room without confirmation that he has access to that room if he really did not have a key? The third requirement is that the danger is not known to the entrant. There is no way that Sarah, the victim, could have foreseen the danger of an unknown man in her room, because it is a hotel room, and logically hotels have tight security procedures to ensure that the safety of their guests are taken care of at all times. I mean, they have security guards at the lobby, they have access cards, they have room key cards that are only accessed by the guests themselves. So how did this incident happen in the first place when there are so many security precautions in place? In fact, Hotel Perdana, being a 5-star hotel alone, should be having a top-tier security system, and it was actually surprising to see that this incident had taken place at a 5-star hotel. The danger was surely not known to Sarah, as a reasonable person staying at a 5-star hotel would expect that they are safe and protected by the hotel's security systems at all times.
So in regards to the last requirement, which is based on the case of Indermore, which is the occupier had failed to take reasonable care to prevent damage from occurring by notice, lighting, guarding or any sort of ways. So in the scenario of the case, it could be said that Hotel Perdana had in fact failed to take reasonable care to prevent damage from occurring, as a man had been simply let in by the hotel staff, allegedly had been simply let in by the hotel staff, in which so many bad things or bad implications could have happened to Sarah. However, Hotel Perdana could still be held not liable, as Sarah had not suffered from physical injury due to the negligence of the hotel staff. So, in my opinion, this is when the law becomes too rigid on the part where it only confines to physical damage and does not really recognize mental damage as a result of the said breach when it comes to proving occupier's liability. So in our opinion, the law should be widened to include the scope of mental injuries and not only confined to physical injuries. The issue is whether Hotel Perdana can sue the trespasser for entering the restricted hotel premise without permission. So to establish whether Hotel Perdana could sue the trespasser under trespass to land, we must first look at the elements to prove negligence. So before moving on, it must be noted that trespass to land is actionable per se, meaning that it is not necessary for the plaintiff to prove that the plaintiff had actually suffered from any damage caused by the defendant. This could be seen based on the case of MBF Property Services Sidian Berhad and Muddy Hill Development Sidian Berhad 1999. Moving on, the rule that can be followed is based on the case of Segar Restu Sidian Berhad and Wong Kai Chuan and another 1994, whereby in this case the plaintiff claimed that they own lot 76 while the defendant claimed ownership of lot 78. The plaintiff further claimed that the defendants had trespassed and built structures on lot 76 and claimed for damages and expenses as a result of trespass that was said. The defendants, on the other hand, claimed that their architect had drawn up designs for the structures and identified the property as Lot 76. Adding on, the Majlis Perbandaran Taiping MPT had actually authorized the proposals and certificates of occupancy were given to them. The plaintiff responded that the building plans were drawn up by a certified building rodsman and it was not drawn by an architect. Furthermore, the plaintiff claimed that the approval of the plans was actually intended for Lot 78, not Lot 76. The court held that the plaintiff was granted damages in trespass even when the plaintiff had suffered no loss, and that the approval of the building plans was in fact intended for Lot 78 as claimed by the plaintiff. The court also made a statement that explains the defendant's scenario perfectly, in which the court regards the trespasser is the one that wrongfully enters into a land under the possession of another person and he had no permission or lawful justification to be on the said land. So applying the case of Segar Restu Sidian Berhad and Wong Kai Chuan and another 1994 to the news article that we have chosen, we could see that although the facts of the case is not similar and to an extent irrelevant towards the topic that we have chosen, however, the subject matter and judgment could be taken into context, whereby in the case of Segar Restu Sidian Berhad and Wong Kai Chuan and another 1994, the court explained the elements for a plaintiff to claim for trespass to land, in which it was required that the land must be possessed by other person, not the trespasser, and that the trespass was made with unjustifiable cost. In proving the elements, we could see that Hotel Perdana was in fact in possession of the land and not the trespasser. Adding on, the interference made by the trespasser could be said without a justifiable cause, as he had hidden in the cupboard and allegedly claimed that he was cheated by someone. Therefore, we could see that that Hotel Perdana could sue the trespasser for entering their restricted hotel premise without permission. So to wrap up everything that has been stated, and to answer the legal issues that we have come up with, which is the first one, whether Hotel Perdana can sue the trespasser for entering their restricted hotel premise without permission. Judging by the facts of the scenario and so on, we have concluded that Hotel Perdana could actually sue the trespasser for entering their restricted hotel premise without permission due to Hotel Perdana can be successful in proving the two elements that is needed to prove trespass to land. Moving on to the next legal issue is whether Sarah could sue the hotel for failing to ensure her safety under occupier's liability. To answer this legal issue, Sarah could not sue the hotel for failing to ensure her safety under occupier's liability because under occupier's liability it is only confined to physical